welcome to Crime in Court. This is another episode of the Canton Cover Up series, Commonwealth versus Karen Reed, and this is episode 110. Bev denies every defense motion and lawn firmness. That title will make sense in just a second. We are going to go over some rulings. So, if you recall, today was actually the continuation of the hearing that started February 18th, which was last week. And that's the one that Judge Bev just abruptly she interrupted in the middle of Hank Brennan talking, lying and misrepresenting facts. And she cut him off. She went off for recess, came back and said, due to the implications of what was just provided to me, I have grave concerns and blah blah blah. So she stopped the hearing. So today was the continuation of that hearing. We're not going to go over it. It was fire. Alessi did all of the arguing for Alan Jackson, David Unetti, and for the ARCA witnesses and the whole defense team. And he basically, a total takedown of Commonwealth and of Judge Bev. He put her in her place multiple times. She was very rude to him, in fact. But it's really worth the watch, and I recommend you go and watch the entire thing on your own. There were breaks and things in between. Bev had to, of course, interrupt. Well, like I said, we're not going to go over that hearing, but I did want to make sure that you knew that that took place today and to definitely go check that out. But what we're going to go over were some motions and things that got on the docket yesterday, which include some rulings from that February 18th hearing. So, all of the motions that they did argue before Judge Bev cut them off, those have all been denied because Judge Bev is just a raging CNX Tuesday. So I'm going to read through this ruling really quickly. It's fairly, I mean, there's several that she ruled on, so it's fairly short. It's just there's a few that we got to talk about. So basically, everything from last week was denied. The defendant's motion to compel video surveillance. So all that video footage that keeps getting turned over in piecemeal and there's no metadata, all that stuff. She's not going to force the Commonwealth to comply with turning that over. If you haven't already realized that she is corrupt as hell, it's not going to get through to you. So this Commonwealth is to comply with Mass R Crim P 14B1G effective March 1st, 2025, which provides in pertinent part that the prosecutor shall permit the defense to discover, inspect, and copy all photographs, video, and audio recordings in possession of the prosecution team. After hearing on February 6, 2025, the parties reached an agreement that the Commonwealth would have a member of the prosecution team copy any surveillance video in the detective files, store the materials on a hard drive, and then produce a copy to the defense. The process would be video recorded. There is no affidavit of an expert or any evidence before the court that the procedure agreed to by the skilled counsel for both parties would result in the destruction of metadata. The process agreed to by the parties satisfies the rule and complies with the court order of October 5th of 2023. All right, fine. She's not going to make them, she's not going to force them to turn over everything they have from the Sally port, which is ridiculous in my opinion. She should be forcing everything over. The motion for pro hoc vice, this one she actually didn't deny, so sorry, I guess it's not every. This motion she took under advisement. She said that the affidavit was insufficient And attorney David Yannetti will be providing an additional affidavit. So she hasn't denied it as of yet, but she's chopping at the bit to, I think personally, she's chopping at the bit to get rid of Alan Jackson. But after today's Alessi argument, it's going to be really hard for her to do that. She can try, but it's absolutely going to get appealed. And uh, yeah. Anyways, moving on. The next one is the motion to compel discovery to request defense request number one was allowed in part and denied in part. The Commonwealth has agreed, and the court orders production of the investigative material sought in the possession, custody, or control of the prosecution team. The Commonwealth has an ongoing obligation to provide items and information favorable to the defense. There is no requirement under Rule 14 that the Commonwealth create items that do not currently exist. So that was one of Brennan's arguments that, well, there wasn't this chain of custody. So do you want us to, we can't just create one. Well, actually, yeah, you should be able to replicate or somehow figure out the chain of custody. You should be able to investigate and figure that out, but they're not going to create something that doesn't exist. All right, so the defense requests number 2, 3, and 4 denied without prejudice. The court does not have enough information to determine whether this request is beyond the scope of the Commonwealth's obligations under Rule 14 or whether the requested discovery is material and relevant. Commonwealth versus Gaines. The court also understands that the materials sought may be protected by a federal protective order. Counsel are free to file supplemental memoranda and/or provide the court with the redacted version that both parties have in their possession, provided doing so is not in a violation of a protective order. Okay, so request number 5 denied. This requested discovery is outside the scope of Rule 14. Defense requests number 6 and 7 allowed by agreement. So though this was allowed because the Commonwealth allowed it. Defense request number 8 and 9 denied in part as overbroad. The Commonwealth must provide discovery consistent with their obligations under new Rule 14A, 14B, and 14.2. Rule 14.2F, definition of work product, does not include any items or information that the prosecutor is obligated to disclose as items or information favorable to the defense. The court is satisfied that the written response of the Commonwealth indicates the Commonwealth's understanding of its discovery obligations as outlined in the rule and the reporter's notes to the rule and of its continuing duty. Defense request number 10, allowed by agreement, so ordered. So if you're keeping tabs, that was denied. Motion under advisement, waiting for she would love to deny it, but at this point it's insufficient, so she can't. Um, Next one, allowed in part and denied in part, denied without prejudice, denied, allowed only by agreement, denied in part, and allowed by agreement. So most of those, if not the majority of those, was denied. So there's that. And part of that, one of those somewhere, I don't know which one, how it was numbered, but part of that was reciprocal discovery. If you remember, we went through the motion for, Judge Bev required the defense to turn over impeachment material before the trial, and therefore what happened was they gave multiple examples in their motion that the Commonwealth prepped or coached their witnesses to where it might have been look, here's this impeachment material that we got. Let's get this out in direct, or however they wanted to do it. So it's possible that it was they were being coached to bring things up from impeachment material that was turned over by the defense. And it's not usually how it goes, I don't think. Like, other lawyers have chimed in and said you're not required to do that, to turn over your impeachment material, because it's basically taking the bang out of your buck. Like, it's taking the steam right out of your energy. It takes that surprise element away when the Commonwealth witnesses are prepped and the defense can't legitimately cross-examine them like how they should. So there's that. So that was one of the ones that she also denied. They're She's forcing them basically now to turn over, or still, the motion was from the defense, can you reconsider your previous decision on making us turn this impeachment over? They were asking, please reconsider. She said no. She denied that. So there's that. All right, this next filing that came up in the docket is it came up next to, in the docket, it says that motion the motion to dismiss for extraordinary governmental misconduct, it has been filed. There are portions of it that they want impounded, and this is Elizabeth Little, or Liza Little's affidavit in support of impounding portions of that affidavit. Or of that motion, sorry, the motion to dismiss for extraordinary misconduct. So Ms. Little says, I do by here depose and state the following. I represent Karen Reed, the defendant, regarding the above caption matter pro hoc vice. Good cause exists to file portions of defendant's motion to dismiss for extraordinary governmental misconduct, supporting affidavit of Alan J. Jackson, Esquire, and supporting exhibits, namely all references to impound sidebar transcripts, references, and information that is subject to a federal protective order, and communications obtained from law enforcement witnesses that are subject to a protective order under order of impoundment, because this court and the U.S. District Court for the District of Massachusetts have issued protective orders concerning this information. So there is information from the federal discovery, the TUI discovery that was turned over in here because it's under a protective order. They talk to or have some communications of law enforcement witnesses that are subject to that protective order. I don't know if that's Michael Proctor or other witnesses, but we know law enforcement witnesses. And what else? She says, so an affidavit from Jackson supporting exhibits. Sidebar transcripts are coming in to this motion to dismiss regarding extraordinary governmental misconduct. So what was said during these sidebars? Was there something that was misrepresented? Is Lolly in trouble? Like, I have so many questions, and there's so much I want to know, and we won't know until Judge Bev finally approves the impounded version, I'm assuming is what she needs to do. And then we finally get that on the docket. It's just, I'm sure it's taking a while. It's probably not going to happen today because the hearing that took place, it lasted all day. And I'm sure they will update the docket later this week with it. I'm hoping we get that on it, that impounded version, so we can read it on here as well, maybe tomorrow. All right, so this next motion is the defense's motion to exclude. So this is the last motion we're going to read, and it's not too long. It's about 6 pages. So The defense's motion to exclude certain testimony of Commonwealth witness Robert Gilman, and in the alternative, request for a Daubert Lanigan hearing. This is pretty rich. So, as the title states, and lawn firmness. We're going to be talking about lawn firmness now. So now comes the defendant, Karen Reed, and respectfully moves this honorable court to exclude the testimony of Robert Gilman concerning the hardness of the ground and in and around the lawn area of 34 Fairview Road in Canton, Massachusetts, in the evening of January 28th, 2022, and the early morning of January 29th, 2022. So this guy, Robert Gilman, is going to testify, or at least that's what the Commonwealth wants him to do, is testify to the hardness or firmness of the ground on the evening of the incident when the Commonwealth is alleging that Karen hit John and he hit his head on the ground, and that's what eventually led to the laceration on the back of his head. And at least that was their argument in the first trial. Who knows what they're going to say in the second trial, but we know that this is, what they're saying or what they have said in the past. So that's what he is going to be testifying to. Exclusion of the testimony is compelled because the Commonwealth has failed to meet its burden under the Daubert-Lanigan framework as to both Mr. Gilman's qualifications and methodology. That is, Mr. Gilman is not qualified to render the opinion on the subject of the hardness of the ground that he proffers. Neither Mr. Gilman nor the Commonwealth has put forth any information regarding Mr. Gilman's qualifications to testify as an expert about the ground's hardness and the requisite geology, hydrogeology, and other like scientific precepts necessary to opine on the supposed hardness. I think I don't know what hydrogeology is, but I'm assuming it probably has to do with like moisture in the earth, in the ground, moisture in the air, perhaps. Things like that. What is this guy's specific qualifications? They don't even give them to him. So I'm assuming what happened was the Commonwealth turned over, their witness list and said, this is going to be one of our witnesses that we would like to call, and here's a report. And that report said this is what he's going to testify to is the hardness of the ground. Additionally, the Commonwealth has failed to satisfy the methodology prong of the Daubert-Lanigan analysis because Mr. Gilman proffers no methodology of any kind. So, yeah, remember, Hank Brennan made that a big point as to, well, there was no methodology used in Dr. Russell's analyzing sorry, that noise, that voice is so annoying I can't even do it. But that was a pretty good impression, I thought. um he he said that, he blamed or alleged that Dr. Russell didn't use any methodology, and then she came back and totally schooled his dog behaviorist expert or whatever. So anyways, so I think it's funny he's saying, or they're trying to give this witness, and there's no methodology used of any kind in this guy's report or in any other materials supplied by the Commonwealth. So they don't even know how he got to his conclusion about how firm or not firm the ground was. So Mr. Gilman cannot show that his lacking methodology is generally accepted in the relevant scientific community as there is no methodology to scrutinize. The failure of either Daubert-Lanigan prong requires exclusion of the proffered testimony. Mr. Gilman fails both prongs. The argument is one of the arguments, the Commonwealth fails to meet its burden to establish the requisite qualifications of Mr. Gilman as an expert to testify about the hardness of the ground. It is the defendant's burden to establish that their proffered expert testimony will assist the trier of fact to understand the evidence or to determine a fact in issue. Proponent must establish a sufficient foundation for a judge to determine whether the expert's opinion satisfies the gatekeeper reliability, whatever that means. The crucial issue in Massachusetts for the Daubert-Lanigan inquiry is whether the proffered witness is qualified to give an expert opinion regarding the subject matter of his testimony. The subject matter of the proposed testimony of Mr. Gilman, as described in his certified weather statement report dated February 3rd, 2025, is the condition, particularly the hardness of the ground in the lawn area of 34 Fairview Road in Canton, Massachusetts on Saturday, January 29th, 2022. An expert witness is not permitted to testify to matters beyond his or her area of expertise or competence. Mr. Gilman received, here's his background. Mr. Gilman received a Bachelor of Science degree in meteorology. He's a meteorologist from Pennsylvania State University in 1979. Mr. Gilman's curriculum vitae, which is just a fancy word for a resume, his CV lists 7 different work experiences, including his current roles as chief meteorologist for precision weather forecasting and New England weather science, positions he has held since 1980. A long time. None of the information contained within Mr. Gilman's CV pertains to the fields of geology, hydrology, or any other relevant scientific field related to the study of the ground in any sense, especially not the hardness of the ground. So, weather and the ground, geology, 2 different sciences, apparently. And they're trying to pass off a meteorologist as a geologist or the like. In fact, none of the information contained within any of the documents provided by the Commonwealth about Mr. Gilman, I keep wanting to say Gelman, I don't know why, Mr. Gilman's profession, let me restart that sentence. In fact, none of the information contained within any of the documents provided by the Commonwealth about Mr. Gilman's professional experience relates in any way to expertise on the subject of determining the hardness of the ground. So he does not have that expertise. The report where Mr. Gilman, the report where Mr. Gilman opines that the ground in the lawn area of 34 Fairview Road in Canton, Massachusetts on Saturday, January 29th, 2022 was hard as a rock due to the frost below. So that's what his report says. And it's signed at the bottom by Mr. Gilman as a certified weather report. Notably, not a report on the hardness of the ground. So frost doesn't mean frozen ground. 2 different things. Mr. Gilman wrote his report and apparently intends to testify in his capacity as a meteorologist, not as an expert of the relevant science of geology or hydrogeology to determine the hardness of the ground. Accordingly, as the Commonwealth has failed to meet its burden to show that Mr. Gilman is qualified as an expert by knowledge, skill, experience, training, or education on the science of determining the hardness of the ground, he must be excluded from testifying on this topic at trial. I mean, you can't get much simpler than that. He's not an expert in the thing you need to be an expert in order to testify to this. Pretty cut and dry. The Commonwealth fails to and cannot meet its burden that Mr. Gilman's methodology is reliable. In order to meet its Daubert-Lanigan burden, the Commonwealth must show that Mr. Gilman's proposed testimony is the product of a reliable principles method and methods and that Mr. Gilman has reliably applied the principles and methods to the facts of the case. The touchstone of admissibility is reliability. The existence of the requirement to show that a proposed expert's testimony is the product of a reliable scientific methodology presupposes that there is a methodology to analyze. Mr. Gilman's report is devoid of any substance which would even be liberally construed as a methodology and any kind for reaching of any kind for reaching his conclusion related to the condition of the ground. So there's nothing in his report that says any kind of methodology that he used in order to determine that that ground was frozen, hard as a rock. So no methodology, no opinion, no testifying to that opinion. The full extent of the information on the subject of the condition of the ground in the lawn area of 34 Fairview Road in Canton, Massachusetts on Saturday, January 29th, from all of the materials provided by the Commonwealth related to Mr. Gilman is as follows. The typical lawn area would have been hard as a rock due to frost below and freezing of soil. How did you get there? How do you know that the soil was frozen? Again, frost and frozen dirt, two different things. As proponent of the claimed evidence, the Commonwealth must prove by preponderance of the evidence that Mr. Gilman's methods and processes beyond his behind his opinion are scientifically reliable. So he has to prove that he used some kind of scientific basis for coming up with that opinion, and so far he has not done that. The Commonwealth induced defect with the application of this legal principle to the present facts is that Mr. Gilman has no method or process behind his bare opinion that even hints at scientific reliability. So there's nothing even remotely hinting at science in his in his opinion there. So a proposed expert's opinion should be disregarded where it amounts to no more than mere speculation or a guess from subordinate facts that do not give adequate support to the conclusion reached. Now, that's a perfect quote that they used from this Rentilla case, where it amounts to no more than mere speculation or a guess from subordinate facts that do not give adequate support to the conclusion reached. So his opinion should be disregarded completely if there's no if all of his if his opinion is based only in speculation and there is not adequate scientific proof to back it up. So the opinion of the proposed expert must be based on more than conjecture, surmise, and speculation, else it should be excluded. Basically saying the same thing. The knowledge of a proposed expert must indicate more than subjective belief or unsupported speculation. Again, saying the same thing. That's three different cases now that they are talking about, including Daubert Lanigan, or the Daubert case that they are citing about not allowing speculation for an expert's opinion. Mr. Gilman's opinion that the ground was hard as a rock cannot be reasonably viewed as anything other than mere unsupported speculation and a subjective belief. For these reasons alone, the court must, as a matter of fact, fail to qualify Mr. Gilman as an expert. Beyond failing to describe any semblance of a methodology in any of the submitted materials, the Commonwealth and Mr. Gilman fail to show that Mr. Gilman's methodology, or lack thereof, is generally accepted by the relevant scientific community, is the subject of peer review, or a reasonable application of the purported methodology to the facts, conditions, and data of the particular instance. Remarkably, neither the Commonwealth nor Mr. Gilman ever use the words generally accepted in any of the submitted materials. So they're just making stuff up. There's no generally accepted, there's no scientific basis, no facts. They're basically saying they've failed to give us any methodology, and they haven't even used the generally accepted the thing that's generally accepted in his scientific community to use for these purposes. Additionally, Mr. Gilman does not meet, let alone discuss, any of the five Daubert-Lanigan factors required to demonstrate the proposed methodology's reliability. The scant material provided on the topic of ground hardness is unscientific on its face. So even if they did bring in a scientist that knew or could testify to this because that's his expertise, it's still not a scientific, uh, it's not, probably it's not legally recognized as scientifically um, sound. Perhaps, is what I'm trying to say. All right, so also the inclusion of quotation marks around Mr. Gilman's description of the ground as hard as a rock is a tacit admission that this analysis is not scientific in and of itself. Hard as a rock is not scientific analysis, it is a euphemism and a common figure of everyday speech, and it does not really mean, it's an expression. The use of lay language where a scientific assessment should be extant is a further showing that Mr. Gilman did not rely upon a scientific methodology to reach his speculative opinion. So just even the fact that he says hard as a rock, just that alone means it's not scientific. It's an expression he just used, a euphemism, and not scientific language. For these reasons, Dr. Gilman's failure to proffer a reliable methodology or any methodology at all. So, not just that he didn't give us a methodology, but no methodology whatsoever. On the topic of the supposed hardness of the ground precludes the Commonwealth from meeting the methodology prong of the Daubert-Lanigan inquiry. As you know, there are, I think it's four, maybe five prongs that they have to meet in Daubert-Lanigan, and you have to meet all of them. So just not meeting one of them disqualifies you. Conclusion: Mr. Gilman is not qualified to render an opinion on the hardness of the ground in and around the area of 34 Fairview Road in Canton, Massachusetts on the evening of January 28th, 2022 and the morning of January 29th, 2022. In addition, Mr. Gilman has not proffered a methodology, let alone a reliable methodology, in support of his opinion on such hardness. For these reasons and for the other reasons stated above, the defense respectfully moves this court to exclude the testimony of Mr. Gilman concerning the hardness of the ground in and around the area of 34 Fairview Road in Canton, Massachusetts on the evening of January 28th, 2022 and the morning of January 29th, 2022 on the papers. So you should just deny this on its face. The fact, just what we've explained to you in this paper, you have enough here to deny it on its own and without the need for an evidentiary hearing. In the alternative, though, if you don't want to just deny this outright, should the court not grant the defense's motion on the papers to exclude Mr. Gilman on his lack of qualifications and his lack of methodology or a reliable methodology, the defense requests an evidentiary hearing to establish the failure of the Commonwealth to meet its Daubert-Lanigan burden regarding the ground hardness testimony of Mr. Gilman, and that is signed by Robert Alessi. So, I mean, wow. They really tear some of these witnesses apart in their filings, and I am here for it and I'm loving it. This person, Mr. Gilman, while he might be the greatest meteorologist there is, I'm not saying he is, but whatever, he is not qualified to testify as to the firmness of the ground. He didn't give a reliable methodology. In fact, he gave no methodology as how he came to this, and he used the words hard as a rock, which is a an expression, something that isn't actually scientifically measurable. Oh, um, there's that. So I sure hope that she denies this on its face, but I have a feeling she'll probably call them in for a Daubert hearing. So the Daubert Lanigan hearing is just like we had for Dr. Russell, and the ARCA witnesses had to do that in the middle of trial as well because Judge Bev is corrupt and biased and yeah. But I, I want to say Bev will just be like, no, I'm going to let him testify. And not even, she's just going to deny this all outright. But perhaps she might give them a Daubert hearing. I don't know. It'll be interesting. I don't think he should testify. It's clear he's not qualified, so there's no reason to go forward with even doing a Daubert hearing. But you know what? Bev likes to waste time, and Karen Reed's money and the taxpayers' money, so she might just go forward with a Daubert hearing for Mr. Gilman. What do you guys think? Will she do a Daubert hearing? Will she deny this on its face? Let me know in the comments below, and I will see you guys in the next one. Please be sure to hit the like button on your way out. Take care. Bye now.